let's see, I'm here to talk to you about something equally interesting, what's new at the Labor Relations Board. So you probably remember, 10 or 12 years ago, we tell you about all these new cases and new decisions that were very restrictive on social media and all these other types of issues. And then more recently, we've said, the MLRB has moved away from that. You can forget about those old rules, and this is the new rule. Well, it looks like we're going to be heading back to the old rules in quite a few subject areas. And we don't know exactly where this is going to land, but it looks like we're going to see some of the more recent cases being overturned and having the old standards reinserted. So, and this is, of course, because the Biden administration, they're having their impact in the labor relations realm. The first thing that, well, not the first thing that President Biden did, but one of the first things that he did was to fire General Counsel Peter Robb, and that happened on Inauguration Day. So he was pretty serious about that. Since then, he has named Lauren McFerrin as the chair, replacing a Trump appointment, John Ring, who is still a member of the board. He had been the chair. His term ends up, it winds down in December of 2022. We're 2021 now. And then there's one other Trump appointee on the board, and that person remains until 2025. President Biden had appointed 2 Democratic members on July 28th of this year. And so now there's a Democratic controlled MLRB, and it's going to be even more so when Member Kaplan's term, Member Ring's term ends at the end of December of 2022. So shortly after that, President Biden appointed a new general counsel. And the general counsel is the person who tends to, well, they don't run the board, but they do have an agenda, and they do try to push the issues that they think that are important, that the board thinks are important. So the new counsel is General Jennifer Abruzzo. She was appointed in mid-August. And one of her first acts was to issue a memorandum called the Mandatory Submissions to Advice. And now a copy of this is located on our website. All of the documents related to this seminar are available on our website. Feel free to visit rodmanwinchell.com and you can find all those documents. But this mandatory submission to advice is basically her roadmap. It's been called her roadmap to her political agenda in terms of the areas that she wants to see board address. And I'm going to go through some of the different areas that we're likely to see changes in. And these are major changes because during the last term from 2016 to 2020, we saw quite a few longstanding board precedents overturned, and we're going to see those re-examined and perhaps even expanded upon. So these, let's see, these are the areas to watch out for. The first is employer handbook rules. Now, we can pretty much expect more restrictive employee handbook rules to be taken to take effect in the next couple of years. Back in 2017, the board had decided Boeing Company, which allowed for a balancing of the employer's business justification with its effect on employee rights. We're likely going to return to the Lutheran Heritage Standard, which basically said that where there are facially neutral policies, they'll still be held unlawful if an employee could reasonably read to prohibit or limit their exercise of Section 7 rights. As you may recall, Section 7 of the NLRA guarantees employees the right to self-organization, to form, join unions, to bargain collectively, and engage in concerted activities for the purposes of collective bargaining or mutual aid and protection. And it's illegal to interfere with the Section 7 rights. And these Section 7 rights apply to not only unionized shops, but to any private employer who is subject to the NLRA. And they have a pretty broad jurisdiction. So that's a pretty important area that we're going to have to perhaps take a look at your personal policies again to make sure that whatever rules are reestablished are being complied with.
Take a look at your personal.
All right.
To make sure that
That includes confidentiality provisions and separation agreements. There's going to be more restrictions on those. The board's going to likely take the position that confidentiality is going to prohibit employees learning about terms and conditions and what other employees have managed to get for agreements with the employer. The next area that we're likely to see change in is the general counsel's burden for showing violations. The longstanding right line test basically requires the GC to show that discipline or adverse job action was taken because the employer engaged in Section 7 rights. The employer would have the right to show that it would have taken those same steps anyway. The GC wants to now require make it easier for an employee to show anti-union animus and pretext. We're not sure exactly how it's going to land out, but that's likely to be a focus of some of the new cases. Union access to employees, that's going to be a big issue in the next 4 years, the next 3 years. And one of the major areas is going to be a battle over employer email systems. We recently, in the past 5 or 6 years, got away from the corporate communications rule that said employees have the right to use an employer-controlled email system. That went away, and we're likely to see that reinstated, perhaps. Employee status. The GC is looking at going back to the more liberal definition of, or actually restriction on who can be a general contractor for purposes of the NLRA. Because if you're a general contractor, then you're going to be not covered because you're not an employee. So they're going to tighten up the requirements for who's a general contractor under the NLRA jurisdiction now. That won't change in terms of our local standard, but if you've got a private company covered by the NLRA, you could see changes, and you could see 2 different standards applied, one for employment purposes or for general contractor reasons for different, well, I'll forget about that. Anyway, we're going to see a more restrictive definition likely to come forth. Jurisdiction over other institutions. The GC is seeking to expand jurisdiction over religious institutions and student organizations. We've had some recent cases that have exempted those, especially students, and the board is interested in taking over those areas again. Employer duty to recognize and or bargain. This is the requirement that when your employees come to you and say they want to meet and discuss some terms and conditions of employment, that you have a requirement to meet with them and to bargain. Now, the difficult thing with this is that even where your management rights clause or even the contract itself expressly gives you permission to engage in an act or an action, the employees can still demand impact bargaining. So that's likely to be expanded upon. And impact bargaining is saying, yes, the employees are saying, yes, we know you have the right to make this change, but there are impacts from this change, and that will impact a mandatory subject of bargaining, and therefore we would like you to meet us and discuss those impacts to see if they can be mitigated. All right, I've got a couple more to go through. Weingarten Rights. Weingarten Rights refers to the right of a union employee to be represented during an investigatory interview that could result in discipline. This happens in a union context. A while ago, probably, actually it was prior to 2004, that was the case for everybody. It doesn't matter if you were in the union context or not. If you have an employee in an investigation that could lead to discipline, they would have a right to bring a coworker into that investigation. In 2004, there was a decision that said that Weingarten Rights did not apply in non-union settings, but the General Counsel and the board are heading back to the old standard, so that may be reinstituted. And then let's see, the final section I'll talk about here is Josh recently mentioned the EATS, or the ETS as they probably should be pronounced, OSHA's new regulations, and while they may be stayed, the NLRA has put out some of their own thoughts on the matter. The GC takes the position that certain aspects of the ETS affect the terms and conditions of employment. Therefore, there's an obligation to bargain. And so whatever is implemented, whether it's mandatory, whether the employer has discretion in how to implement, that's going to impact employees, and therefore they have the right to either bargain or impact bargain implementation, should it ever happen. It will happen in some form at some point, I'm sure. All right, so expect big changes. Hopefully we'll have some more hard and fast rules for you next year, but right now we just have these lot of issues and areas to keep an eye on in the meantime.